Welcome back, everybody. This is Pascal from Neutrality Studies, and today I am joined by Dr. Juan Branco. Juan Branco is a French and Spanish lawyer and activist who, among other people, advised Julian Assange during his trials, and he's currently advising my compatriot, Nathalie Yamb, about the EU sanctions regime. Today, we want to discuss, again, the sanctions, what they mean for the people who are under the regime, and what it tells us about the rule of law in Europe. Juan, welcome.
Thank you very much, Pascal, for your invitation.
Thank you for taking the time for this. You've been one of the people who's been time and again standing up and using the law as a practicing lawyer, as far as I understand, to help people who are being persecuted, for the lack of a better word. Can you tell me how you are looking at the EU sanctions against individuals inside and outside the EU?
Yes, we've had a fascinating case with Nathalie Yamb, who I recall is intellectual, an African intellectual, Swiss Cameroonese intellectual, who has been denouncing for more than 20 years the persistency of France-Afrique, which is the interconnection between French interests and elites that predate African resources on the continent. And she's been very constant in this political endeavor. And a few years ago, she gave a very famous speech at Sochi, in which she denounced again this system of power and announced that Africa would remain independent, whatever the cost, but that they would welcome any kind of allies, including Russia, if they respected them and treated them as equals. And this unleashed from the French authorities under Emmanuel Macron rule fury against Nathalie Yamb, and they immediately targeted her as the main to destroy, and they used her as a justification for the failure of their policies in Africa. And so this brought a lot of legal measures, including une interdiction d'entrée sur le territoire français, so she was banned from entering French territory. And a few years later, a few months ago, a decision from the European Union banning her from entering or even flying over European Union territory, but also, of course, seizing all her assets. And the only link they ended up finding and establishing between Nathalie and Russia was the fact she participated in a conference in Berlin in which there were several MPs, European MPs and German MPs that participated. And this conference apparently was financed by an NGO, which was itself financed by armed groups called Wagner. So they used this very small, tiny, not even link, but connection at some point, which didn't bring any kind of resources to Nathalie because she wasn't paid to participate in this conference, to justify these extraordinarily violent measures, which were not taken following any kind of judicial standard or like anything that we relate normally to the rule of law. So, for example, there was no contradictory process before because they considered that the surprise effect is critical, which one could understand if we talk about the seizing of assets, especially for assets of big corporations in the military world or for oligarchs. We could understand this, eventually, because of course money can move very fast. But regarding first an intellectual who has done nothing else than using her freedom of speech rights, but also, and it's even more important, an intellectual that is being targeted for physical restraint measures, because she cannot come back to her home country. That's actually the novelty of this case. The novelty of this case is double. First, the fact that she cannot come back to Switzerland because Switzerland is enclaved in the European Union. And this is something I think the European authorities had not foreseen and understood that it would be a huge legal issue. And the second one, that she's being targeted only for words, and not because she would have any interests, direct or indirect, to the Ukraine war or to any of the structures of power close to Vladimir Putin, for example.
May I ask you though? We have several such cases by now. I mean, a second one is the former Swiss Colonel Jacques Beau, who's actually in Brussels and who's now also caught inside Brussels because if you are on this sanctions list, you are forbidden from traveling over member state borders. We have a German national, Hussein Dogru, inside Germany. What how do you make sense of this regime, and do you think it will stand over the long term, that it remain possible to treat people like this?
Yeah, so we welcome Jacques Beau joining us in this struggle, even though it wasn't completely voluntary from his side, because he gave more visibility to these kind of measures, which were more or less accepted until then. I mean, I have to say that the Swiss authorities did not implement the sanctions against Nathalie Yamb quite clearly, because they made no sense, and until a few years ago it was almost automatic. Switzerland would immediately implement wherever EU sanction was taken against an individual in relationship to Russia, and they've slowly started to distance themselves and not provided any kind of assistance. I have to say it's been quite embarrassing, because Nathalie Yamb was in a foreign country when she learned of these sanctions, so she was stuck there with no material capacities to find solutions for her survival, simply because her assets were freezed at the same time as she was banned from traveling. And you have to understand that these sanctions go way beyond the simple capacity to come back to your country. Any company that, for example, has activities in the EU will preventively stop having any kind of economical interaction with you to protect itself from potential sanctions. I don't think this. I mean, there are several options. Either this system generalizes, so we know that the originators of these kinds of structures were the United States with their sanctions and ban lists. But if we start imitating them, and as we have, and other countries start imitating us, we're going to soon have a world which will not be functional, in which it will be every country will have its own um, sanctions list, and thus any company, for example, will be afraid of trading with X and Y, because in this country that person is sanctioned, and thus if you start trading with that person, you might eventually find yourself sanctioned. I mean, this happened, for example, to a French bank, BNP, Banque Nationale Paribas, a few years ago. They had billions in sanctions from the US because they had kept on having relations with an Iranian company, and because they were trading in dollars in their other activities. I mean, they were liable in front of the United States jurisdictions, and had to pay one of the biggest fines that were imposed on those matters. So we know that this is structurally an abuse of power, the construction of these instruments. I'm talking now in general terms, and in individual terms, it's extraordinarily violent, because, as I was saying, there is no warning, and there is no possibility to deliberate the decision before it is taken. So then you can go, as we did, to the European Tribunal, and so the General Courts, which took 4 months to decide on whether it was an urgent case or not, and they decided it wasn't. So this is very interesting. If seizing all the assets of someone and blocking that person from coming back to its own country is not considered as an urgent issue for a court, what is an urgent issue? If you look at a bit broader, in a broader perspective, the jurisprudence of the General Court, and then of the Court of Justice of the European Union, you realize that the lifting of sanctions is barely existent. You have maybe maybe around 10 examples out of thousands of sanctioned people, and all these proceedings that were open to try to lift them. The European courts do not consider that this is a matter under their jurisdiction. They consider that it belongs to the exercise of the power of the natural power of a sovereign in its international relations. So they do not consider that this is human rights or individual rights subject when it's clearly the case. So they only have a very tight control over very small elements, which is in case of clear abuse. For example, when you have a confusion on the name of the person, you have confused two people, then eventually you can have some kind of control. And the most ironic part is that when you have a control, most often the European Union and the Council of the European Union decides to impose new sanctions over slightly different grounds, even before the previous one has been lifted, so that the person that is targeted has to start again all this judicial process that can take up to 2 or 3 years if you take into account the appeal time. So making it actually avoid system of law and an impossibility to challenge it factually.
And we have such cases, right, where individuals actually won at the European Court of Justice their case, and they were just simply relisted, basically immediately with a modified justification, and then the whole thing started anew, and they're still being sanctioned.
I know only of a couple of cases in which this didn't happen, and it's actually ironically the son of an oligarch, for example, that was able to avoid this system of simply reinstating sanctions once they had been lifted by a tribunal. So that's something I have argued before the court, which is to say you cannot pretend that there is some judicial control, because of course then they have this tautological argument in which they say that it's okay for the sanctions not to have a pre-use contradictory phase, because then there is judicial control, and then you tell them that there is no actual judicial control. So we're entering into this argument in which we're actually challenging even the legitimacy of the court and its and the exercise of its prerogative. So of course it becomes first very tough and violent. The exchanges we've had are like tougher sometimes with the court and even with the Council of the European Union, because we're basically challenging the raison d'être of this judicial review, judicial review, and trying to push them to their boundaries to understand that it's a system in which there is no possibility to win if you're behaving as a normal person. And on the other hand, we're trying to give them these novelties from this specific case, which, as you said, then Jalubo has followed the path, but which is the fact that it's really the first time in which just because you spoke or wrote something, you can have legal sanctions that are actually much heavier than most legal sentences, even in criminal cases. Like if you look at the average sanction that you receive from a criminal case in Europe, it's most often shorter in time and with less effect, because most of them are without execution. You have like this symbolic conviction, but you don't actually go to jail or so forth. Here you have an actual factual sanction with the inhabilitation of your capacity to survive as an economic person, and the inhabilitation to come back to your family, to your work, to your place of residence. That's first thing. And then the second is the length and the duration of these sanctions. It is extraordinarily long. There are cases of sanctions that have been prolonged for more than 10 years. And so you have a situation in which you have an indefinite sanction, and which is akin to a criminal sanction in terms of impact, or even sometimes worse. You have no previsibility. That's also an important issue. When you get convicted by a court, you know to what you get convicted. You get convicted for 1 year sentence, 2 year sentence in jail, or to home arrest or house arrest. Or here, it's unpredictable how long it will last. It can be prolonged for as long as the Council of the European Union, decides to, and this creates also an anxiety and a different form of violence that, in some ways, is worse than what happens when you are in a criminal proceeding. And of course,
So how
yes, sorry, with you're not hurt. I mean, you can hire a lawyer if you manage to find a way to find money and to find a way to pay him in spite of those circumstances. Though this lawyer will only have your case heard months or even like more than a year after you have initiated it. I mean, it's completely absurd. Absurd.
So, I mean, the regime itself is absurd, and unfortunately, I have heard people from the international law background who actually said, "Oh no, they're fine with this because you should not, and nobody should ever be allowed to defend the aggressor of a war of aggression, and be, since the European Court of Justice is responsible for these cases, there is a judicial process, so no problem there." As long, I mean, everything is fine, but everything is not fine, is it? Like, this is an executive order from an executive organ that has a tremendous human rights impact on the victims, and nobody is safe because they didn't even commit a crime, right? They committed something that was never actually defined as a crime under the European Union statutes. How can we use law to fight against such blatant injustices and miscarriage of, I would
So,
say, legal order?
so the subject of definition is actually also an interesting one, because you have all these very long texts that serve as support to for those sanctions, and they're written in such an impossible to understand language for a normal person, like all these Brussels jargon that is barely understandable even for a lawyer. I mean, you spend hours just trying to understand to which provision has been used to sanction your client. You have all these very specific categories which are trying to be mixed in order to construct some support to the final decision, but it creates even in terms of pure language, sentences that are difficult to understand or that have no meaning in their normal language, because it's just like a junction of different categories that are used to try to fit together all these results, I guess, of negotiations between the 27 countries of the European Union and their authorities. And we've had some hard arguments with the court and the Council of the European Union about this, about the lack of legibility, the lack of understanding of what they actually meant in some times, and to what disposition they were referring actually when they were trying to justify the sanction against Nathalie, and that's an issue because. So they adopt these huge texts in the midst of, let's say, the Ukraine-Russia war. And so you have all these emotion about what's going on, and the fear and the media pressure and so forth. And then they create all these openings for the extension of arbitrary decisions and of the competence of the Council of the European Union against its own citizens, which is extrajudiciary. This is really, I think, this is the term that we should memorize regarding this kind of dispositif. It's extrajudiciary sanctions, and which of course have some political objectives. For example, for Nathalie Yamb, it was France which proposed it to the Council of the European Union. Actually, the Council of the European Union at some point asked the court for France to be authorized to intervene in the case, because they had no arguments themselves to defend their decision. That's another fantastic situation. This Kafkaian system is that for some reason they have decided that in order to build up this kind of legitimacy, to build up their things, they decided that they could only use open source evidence. So when you're presented, so you have the decision, okay? It's a 3-line decision written in this Bruxellois impossible to understand language. So you have to go to all the text, and then when you write to the Council of the European Union, you ask for the evidence supporting what they stated in the decision. So they send you this, and this file that they send you is what will be discussed and will serve as an argument from the Council of the European Union in front of the General Court of Justice. So they send you this set of 15 to 25 articles, press articles, or think tank publications, which basically all quote each other, because it's often so. In these cases, Nathalie, one article says Nathalie Yamb was in this conference in Berlin, and actually it is suspected that this conference was financed by the NGO, which was financed by blatant. Okay, this is the starting point. And then you have 10 articles either commenting or recycling that information without providing any further elements. And so you have this documentary basis, that's how they call it, evidence file, and which is then filled with all the, because most of that's also a very interesting thing, no? Most of the publications are produced by think tanks that are either directly or indirectly financed by NATO, which is not part of the European Union institutions. It's as foreign to European Union institutions as, I don't know, any other system of power or organization. And so you have a military organization that is actually one of the main actors of the current conflict between Ukraine and Russia, in which, again, I must recall this very simple evidence, but which seems to have been forgotten by most. We are not at war with Russia today, and no country of the European Union today is at war with Russia. So they invent this concept of hybrid war to justify that they take measures that could be legitimized under a war system or war situation. And it's actually in the text, in the regulations that are used against people like Nathalie Yamb. They try to define what hybrid war is and what hybrid war measures are. And basically anything, including a tweet, can be qualified as an act of war, of hybrid war, which is not war in this text, and thus can legitimize the sanctions. So they open with such extent all these categorizations that you end up and then you end up discussing what this I don't know, Atlantic Council or a blog art posts. It's literally this kind of. I'm not talking about like intensive research from this group of 15 researchers from Oxford, Cambridge, Tokyo, blah blah blah, which would gather together to work on it. No, it's just this. Maybe a postdoc or master student that has written in a blog post of the Atlantic Council something against Nathalie Yamb, and boom, they send it to you and they say, this is what we have based our decision on to sanction her. And when you tell them, I cannot defend someone against hearsay, like you need to produce me actual evidence that something happened and not just what someone says that someone has said. They said, no, we cannot do that because that would vulnerate the rights of Nathalie Yamb, because basically the European foreign affairs ministers, which are the ones who decide who gets into the sanction list or not, are not judicial authorities. And so they don't have prosecution authority. But you see how Kafkaian everything,
Yeah.
so
That's pretty insane. So you basically take away the basic human rights of these people, and then you do that because of some articles on the internet that are free and open access. And the reason why you do that and not use actual materials that you gathered from a criminal, let's say a criminal case and research, is because you don't have the legal right, because this is not a criminal act they did, so you can only use what's public, and then you use that and say like, oh, we need to protect their privacy rights in order to take away the human rights.
We cannot have, as foreign affairs minister, access to a judicial case because it's secret, it's protected by all this national disposition, which is true actually. And because of course, how do you contradict something that is a report from DGSE or DGSC? And so in their absurd world, there is a coherence and a rationality to act as such. But the result is that you just create a suspicion, and in some way you nourish it by also triggering all these decisions based on these rumors. Like there's this autotelic system in which you actually end up condemning someone for what was just hearsay without having given her any possibility to defend itself, because if you had given them the possibility to defend herself, you would have vulnerated her rights. And you look at that as a lawyer and you're like, okay, this is going to be complicated. And so I try to explain to the General Court of Justice that this is not their system of thought. Is not at all compatible with the basic fundamental human rights protections that are that are included in the treaties, but also in the European Convention of Human Rights and so forth. But it's very complicated for such a court to admit that they're basically destroying lives in violation of what they're supposed to protect. So it's all this, also humanly speaking, very complicated to bring forward. So again, Nathalie or Jacques Beau have this advantage that they cannot be demonized in the sense that they have no direct or indirect implication in the armed conflict. So there is no possibilities to have for the judges this prejudgment on them, or even like they're not oligarchs with billions of euros or dollars or rubles, because even that creates already a preconception in the judges. No, he's such a rich person, he's not European, so we can sanction him, it's not too bad. No, here for the first time we have normal citizens with limited resources who have just expressed their opinions and whose rights are affected way beyond what the rights of an oligarch would be affected on. And I'm talking about oligarchs, but I mean, all these grounds to come on the ground of all this, of course, as you know, is terrorism legislations, no, and on this war on terror that was launched in the early 2000s. And again, I mean, for those kind of people, I don't know, let's say someone in Yemen, you're a European judge from Brussels or Strasbourg or Luxembourg in this case, you don't care much about what will happen to him, and if he's not a human to you, no. Nathalie has felt this difference of treatment because she was also African. She felt her case was not as covered as the one of Jacques Beau, and that there was some kind of indifference towards her. But she was not considered as a full Swiss. You know, there was still this I mean, implicit presumption of and racist perspective. But now with Jacques Beau being sanctioned, also we're hoping that's not only in Europe there would be some debate, but also in Switzerland, because it becomes also a sovereignty case for Switzerland. I was having these huge arguments with the different services in the Confédération Suisse, telling them like trying to activate their pride, also reactions, no, telling them like, you have to realize how this is going to expand. I mean, you're letting some of your citizens have their basic human rights. You have to intervene. For example, for Nathalie, I thought it would be natural for them to provide her some sort of diplomatic protection, you know, to tell her, and she's abroad, she's unable to fly, she's being targeted by a foreign entity, and having her main human rights violated. We also invoked the Barcelona Convention on the right of transit, also the protection of the right to return, because for like all these basic instruments that suddenly seem to be not to be so important, because there is this huge objective which is kind of indefined also, because again we're not directly at war. So there is this contamination that is extraordinarily disturbing and dangerous, and also makes us realize then that what we have a belief that the positive relationship to law has been structural in the Western Hemisphere. It's not the case. I don't know if it has ever been the case, but it hasn't been the case for a long time. And what I was telling you a few moments ago about how the lack of concrete evidence is being advanced to actually try to justify the decisions against Nathalie, this is a direct result of the extension of judicial arbitrary in the war against terror. So in France, you have more and more cases in which you are judging someone not against the evidence that are shown in court, but against what the secret services have said on that person from elements they have collected outside judicial control, which then they whisper to judges to tell them this person should not be able to exit prison, or like should be condemned because she's dangerous, and we couldn't bring this evidence to court because we need to protect our sources, or blah blah blah. But we still think that, and you have all these series of phantomatic cases which have been developing in France. And again, we didn't care because it was like extreme violent Muslims, or some people who were from I don't know what origin, and so therefore like the citizen didn't feel that they were threatened or directly targeted by this kind of expansion. What we will see is that as the horizon of war expands, and legitimacy of our structures of power shrinks, we will see more and more these dispositives being used to target legitimate use of freedom of speech and normal citizens in order to try to silence them or intimidate them. I mean,
No,
I don't know if it's your case, but I mean, I think it's natural and I think it's honest to say that this, of course, has inhibited me in some ways. I have been careful about either talking to Russian media, to Russian scholars, to Russian lawyers, including human rights scholars and human rights lawyers, because of the potential consequences that the simple contact with them could trigger. So this inhibition is already happening, and today it's with Russia, and tomorrow it could be with any other country. We also have to take that into account.
yeah, no, the intention behind the sanctions on individuals, also the ones living inside the EU or being part of the Schengen area, like Switzerland, is very clear. And the German foreign ministry actually in an interview, not in an interview, like in a reply to a question by a journalist, actually said outright, look, anyone who's a propagandist or a friend of Russia should now be thinking about what they're doing twice. So they use this as an intimidation tool. It's just that this is possible inside the European Union, that it is possible to switch off all the legal protections that EU citizens should have. I mean, apart from the fact that this has been used for years in order to crack down on people outside the EU and human rights activists in Africa and all over the place, is that's already horrendous, and that this is now being turned inside. It's just it really takes off the masks of the system. It's just how could the legal process be used? Could the European Court of Justice be used to invalidate the entire practice? Is that what you're after at the moment?
Yes, of course. I mean, that's why Nathalie trusted the idea that of bringing the case to the court and to see if they would lift these sanctions, because this situation is so outrageous that I mean you can have a debate over the old principle of sanctions, whether it's positive, negative. I think it's a catastrophe, and I think Europeans will pay it very highly because other countries will not stay without reaction, and at some point they will start trying to implement similar systems. Also, just because they will feel inspired by what we're doing. It won't be also only in terms of retaliation. It will also be simply because they think it's a good instrument, and I think we will create some anarchy in the world by doing so. But aside from that, I mean, and aside also from the fact of, I mean, why Russia? Why not Israel? Why not? I mean, simple questions. Why do you focus on specific non-adversarial in terms of direct warfare against you entity? That's also a question. Then you have all these specific elements that I described about Nathalie's case that made us optimistic about the fact that if there was a case to be won against that court, it was Nathalie Yamb case. Like if there is one shot at invalidating or at least putting a limit to what can be done or not under this legal regime, it was against a non-EU citizen which lives in an enclaved country inside the EU, and thus for which basic human rights, like the right to come back to its to principle of return, so the right to come back to its own country, are affected by this disposition. And the fact that, I mean, if you take such decision on the grounds of of freedom of speech use or abuse, you of course need a specifically more protective regime. So these two elements combined brought us to bring to the court the argument that it was not as all the sanctions that had been taken until then, but it was a new kind of regime, which, because it affected fundamental human rights of Nathalie Yamb, unlike the others, that's the jurisprudence of the court, needed to have a basically contradictory phase before they were taken. She should have been granted some rights that were violated, and thus the sanctions should be lifted also on procedural grounds, not only on the merits. So, and I think we're right. I think we're completely right, and I think if we lose that, we will open a path for abuse, which will be very, very difficult to close afterward. And we have felt that that they're not feeling comfortable with the situation, and I think that's why the exchanges have heated up. And because I mean, their legal basis is very weak. It's very complicated for them to legitimate themselves and to legitimate that action. Their evidentiary basis is basically non-existent, and so we'll see how the reaction is if they, out of pride, keep on pushing. And for example, regarding the mesures provisoires, so the measures that were asked for in order to try to before the decision is taken, the final decision is taken to lift the sanctions temporarily. It was rejected in a very weird way by the president of the general court. So we brought it to the to the higher court, to the appeal, and we're confident that, I mean, that there will be a favorable decision to us, but it will be maybe in total 8 to 10 months after the initial feeling, you know, like, so that's is to have provisional measures. So imagine the length of the overall process, and you cannot expose normal citizens to that kind of deprivation of their fundamental rights for so long without serious judicial control. It's absurd, and the court is not built to react quickly. So you have this contradiction also that is that is difficult to handle now from structural terms. You know, like how the court functions, and they're not meant to. It's not like courts in national structures which are meant which can condemn you on the spot, or on the contrary, make sure that you will be liberated if you have been unfairly detained. These structures are built to handle complex, very long-lasting cases, and not to treat urgencies like these ones. So that's another issue.
Okay, so in conclusion, in the last 2 or 3 minutes, what's your plan of action for the short term? I mean, your plan is to work on the European Court of Justice. It's not to escalate, let's say, to a human rights court.
It's you don't have you cannot bring, that's also the irony, no, you cannot bring the European institutions towards la convention, I mean, you can, yeah, you can allegate dispositions and jurisprudence of the Cour européenne des droits de l'homme, the European Court of Human Rights, inside the legal actions in the European courts, but you cannot bring to the European Court of Human Rights EU institution. So you're locked into that incapacity. So I mean, there's been discussions for years about authorizing this and bringing, signing an agreement between the European, I mean, the Conseil de l'Europe and the European Union to allow this. But for now, it's not the case. So, I mean, you can go to the UN for sure, as would Emmanuel Macron say. And so what? I mean, what would bring it? What would it bring to Nathalie? What kind of either favorable decision or a favorable effect would you get in the long term, or even in the short term? You wouldn't. So we can do all this effort, and maybe together we can do it, but we have to also accept that we're in a historical phase in which all this world order from post 1945 is collapsing, and those institutions which were already structurally weak and had trouble in triggering any kind of effect now are, I wouldn't say they are doomed, but not far from doomed. And I don't think we should place much of our trust nor our efforts in trying to revive them and trying to relegitimize them by actually going to them. I think we have to accept that we're lonelier and lonelier in this world, and unfortunately that we have, it's only through the relationship of powers that we can try to change things. So it's direct interventions against state authorities, trying to also bring the public opinion to be aware of this kind of decisions and the abuses that are committed by their authorities. I have to recall also that French authority, which has brought this case to the Council of the European Union and has had the European Council of the European Union to adopt this decision, is not very legitimate from a liberal democracy system. In the Minister of Foreign Affairs is member of a party which was one of the most minoritarian ones in the last elections, but because this weird institutional system in France and the decision of Emmanuel Macron, he has managed to maintain and impose a minoritarian government in France. So you have this minoritarian government in their own country, which is sanctioning people who are not even part of the structure of power that is sanctioning them and triggering extraterritorial effects in the Confédération de Suisse against the Switzerland, a Swiss citizen. It's absurd, it's dangerous, and also it's maybe a historical lesson. The weaker the powers are, the more dangerous they become, because the less attached to the respect of the rule of law and of rules in general they show themselves to be.
Yes, it's highly ironic that this is coming from the people who tell us that they're there to protect democracy and the rule of law and so on. But this is the world that we are living in, and we need to deal with reality, not with a fairy tale land. Juan Branco, thank you very much for defending Nathalie and also all of us indirectly, because this is a fight for everyone's right. Is there any place where you publish news or your analysis where people could go and read from you?
Yeah, you can follow me on the social networks in general. I think I try to give information about the evolutions of these situations and how we try to fight for a better world, in other words.
Everybody, please try to find Juan Branco on Twitter X and in the other social media apps. I will try to link them in the description box below. Juan Branco, thank you very much for your time today.
Thank you very much for giving me the floor.